Hello and welcome to the Kenneth for Camel Law Office Legal Podcast. In this edition, we look at what happens if someone who is not married does not have a will. Well, number one, it's very important to have a will, but if you're not married, or if your will wasn't done right because you used a cheap form online yourself, then the procedure to distribute assets becomes much more complicated. It will require all of the children to select someone to be the administrator, then all the children to sign a renunciation affidavit in front of a notary. If all the children do not sign the renunciation in front of a notary, then a complaint order show cause must be filed in the Superior Court, usually with a cost of over $3,000. I'd say if there's no children, then nieces, nephews, and others will have to spend even substantially more. The preparation of a will for under $400 eliminates these costs. Two, there's additional expenses will be incurred in extra work because a surety bond will have to be taken out with fees of often $1,000 or more. Let's say having a will eliminates the need for having this surety bond. Three, state law determines who gets their assets, not you. Sometimes people who dislike you or don't care about you get your assets. Four, if you have no spouse or close relatives, the state may take your property. Let's see, most people would rather have charities or friends get their money than the government. Five, it often causes fights and stress within your family and sometimes lawsuits. Six, if there's minor children, a judge who's estranged determines who gets custody. So having a will is something very important, and it's not that complicated. Basically, you contact the attorney, they mail or email you the questionnaire, you fill it out, and set forth who's going to be executor number one, who's going to be executor number two. Then who's going to get your assets, and in the event that one of those people dies ahead of time, then who would get that person's share. If someone has specific requests, then you indicate who's going to get the assets there. What our office does in Edison is we mail out the drafts ahead of time. This way someone can read the hard copy, and then when they come in, they're asked three simple questions. Have you read it? Does it contain what you want? And do you have ID to prove who you are? The client always takes the original home because that's their property. For more information on having a will and the problems of no will, visit website njlaws.com. And for representation, contact Ken Verkammen's office in Edison at 732-572-0500. Thank you.